Meeting. Let's start with a roll call.
Alderdorf here.
Alder Corpus Dax.
Alder Captain LaFave here.
And Alder Galvin is also here. Looking for a motion on the agenda.
I'd like to, before we approve the agenda, move that we move item 3 up to before item 1, which would make it.
So item 3 would be moved to item 1.
Second. Oops.
All right. In favor of that?
Aye.
Aye.
Passes.
Who seconded?
Who seconded that?
No. Corpus Dax.
Corpus Dax.
So we'll be moving item 3 up to item 1. All right. And I'll entertain a motion on the minutes.
Approve the minute, move to approve.
Second.
All in favor?
Aye.
Aye.
That passes unanimously. On to regular business. So, item 3. Consideration with possible action on an intergovernmental agreement with the Green Bay Area Public School District to permit off-duty police officers to use the City of Green Bay Police Department uniforms and equipment. Staff.
We have our law department to speak to that.
Let's see.
Good evening, everyone.
Good evening.
So the agreement obviously is between the city and the school district. It will allow off-duty officers to work in the schools during the 4 high schools during the lunch periods and certain athletic events like football games and possibly dances and any other circumstances where the city and the district determine that a police or a security officer's presence is necessary. So the officers will be off duty, and so they'll be paid by the district, subject to the district's employment policies, but they will be able to use Green Bay uniforms and patrol cars and their equipment so that there will still be a visible police presence in the schools and in the neighborhood to make sure that the communities are being kept safe. We have some reps from the school district as well as Commander Abel here if you have any specific questions for them. Otherwise, if you have any specific questions for me.
Alder Dorf.
For you, so that we have not had this type of agreement written in place before.
Correct.
It has been a process since I was an associate principal in 1998. We have had officers fulfilling these functions, but this is the first time it would be written.
Correct.
And
Yes.
what brought us to this? Why?
Police officers off duty are no longer allowed to use their GBPD to wear their GBPD uniforms when working for other places.
And why did that change?
I'll handle it.
Okay.
So, essentially, what happened was about 6 months ago, maybe a little longer, it came to our attention that officers were working off duty while wearing their uniforms with the assumption that they were falling under the umbrella of the city's insurance and our liability coverage, and we would be assuming responsibility for all of that, despite the fact that we had no control over their behavior while they were off duty. And so, in speaking with our insurance carrier and investigating the law around it, we determined that it's really not the best practice. If they're in their uniform, they're presenting themselves as officers, then they need to be on duty. And so with that, the change was implemented and actually took effect the first of this year, that officers are no longer allowed to wear their uniforms in a private capacity when serving as security officers. The issue with the school district is they do still need kind of like a quasi function where they have the police presence, but not necessarily need a full-on police officer. So what we determined was the best approach was a cooperative agreement. So under the state statutes, there is an opportunity for municipalities and school districts to work together to use their joint powers to allow things like this to happen. We've kind of redefined what are considered the school grounds to accommodate those gathering areas where school students gather during the school lunch periods and whatnot. So it's no longer just the school grounds, it's the adjoining parks that we might own, stuff like that. And so we are really just cooperating with the school district to make what they need happen, what we need happen. And so this way, we still maintain the integrity of our position of when you're off duty, you aren't wearing your uniform, and it's clear to the public whether or not you're serving as a security guard or you're serving as a police officer. And then when we have governmental entities who are in need of a higher level of service, because we are governmental entities, that we have this cooperative agreement to allow us to work in a slightly different manner.
So
And the
I
others-
noticed you used the word best practice, the words best practice, but so it wasn't necessarily illegal to allow them to do it? Help me understand more about what you meant by what it's not best practice.
So essentially, if the police officers are outside working as independent contractors and they punch somebody, the city's on the hook if they presented themselves as officers, regardless of whether or not they were actually acting as an officer. They could have been completely gone rogue, but they've got that air of authority behind them, and so we would be making an argument saying that we're not covering you, but we would have somebody outside who got punched coming and suing the city, and we'd have to deal with that, and we might be exposed to liability.
And so by putting this agreement in place, as I read through it, it looks like it puts the liability on the school district, if there is any. Okay, so that protects the city.
Yes.
then.
Yep.
And this is, we are trying to refine it. I mean, we realized this was kind of not the top approach that we could come up with. This was something we needed to get in place really quickly. And so we're going to be looking to figure out what would work. So this one ends at the end of the school year. We're already working with the school district to figure out if there's going to be anything that we need to fix. And then on top of that, we're also going to be looking at what's happening to see if we need to fix stuff in the interim. So you guys will see another one in another 6 months or so. This one is just, we need to get something in place to make it happen. This is going to be pretty close to what it's going to look like moving forward. But we also recognize that we need to refine this process as it moves. And so that's why it is only until the end of the school year where we can really take our time and figure out what needs to happen.
I don't have any other questions.
Anyone else? All right, I have a few questions. So the school is responsible for their actions.
Correct.
Who's responsible for supervising them?
So what we have ultimately decided is that the officers are going to be subject to review by our officers, but it is still only in their capacity as school district employees. So any findings that we make are referred just to the school district and not part of the actions of the city. But this way, that's kind of our cooperative function, which is we're assisting them with that portion, because there is a kind of a quasi law enforcement component to it, because we are still kind of doing more than just, because we still have our uniforms on. And so the police officers will still be following, the police officers will still be subject to review by our police department, internal affairs, but the results of that gets forwarded onto the school district to determine what they want to do with their security officers. So the discipline wouldn't be handed down by us because they're not ours, but it'll be handed down by the school district.
Okay. Workman's comp, all that is being through the school district? How is the city being compensated for this? I mean, how is this, who pays them? Does the school district pay them? Do we pay them?
The school district pays them. They are private employees of theirs. They are not affiliated with the city during the time that they are on. They are on duty with the school district.
Do we get financially compensated for the use of the equipment?
No, that's
Or
part
is
of
this
our
a quid
cooperation.
pro quo where we've got extra officers out there now in uniform and squad cars patrolling parks and schools?
It's more, yeah, I guess you can see it that way, yes. So it's just a cooperation between the two of us, seeing the joint benefit to it.
So the school is responsible for who they want to hire and who they want to fire.
Correct.
All right. And, all right. I have some other questions, but I think I
Wait,
direct
can
that
you-
more at the school district.
Oh.
Okay. I'm going
Anybody
to.
else? Should we open up the floor?
Yes.
All right, move to open the floor. Second.
All in favor?
Aye.
That passes unanimously.
Okay, so we'll have
Whoever wants to come on
Melissa
up.
Phil is the attorney, Vicki Byer is the assistant superintendent. They'll introduce themselves,
Good
of
evening.
course, and say where they live, which of course is what they have to do, so.
Yeah, we just need you to identify yourselves and
Sure.
your address.
Melissa Thiel Collar, I'm the District Legal Counsel, and we're at 200 South Broadway, downtown.
Vicki Byer, Associate Superintendent.
Okay. So, I mean, PD has always kind of worked for the school, and sheriff's deputies have worked for the school district in the past. Are you going just with Green Bay Police now, or are you still going to be working with other agencies, or just Green Bay?
It will be Green Bay.
Okay. Does this include just within the city of Green Bay, or is it going to include school property outside the city of Green Bay?
We're focusing on the secondary schools right now.
Okay.
Continuing the practice that's been in place, as Alderman Dorf had mentioned, for quite some time now.
Okay, but also now, like special events, like dances, sporting events,
Correct.
whereas before it was just the SROs that were doing that.
No,
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 they had-
always, even when
Yeah.
I was
Oh, they did?
in AP
Okay.
in the 90s.
All right.
Yeah.
And then, so you guys will interview, hire the individual officers and work out a compensation package for them, whatever.
And we already have. They're-
Okay.
They're already currently, well, we've been in a hiatus since the policy has changed, but we've had a pool of officers who have been doing this for, going back to when Alderman Dorf was on
Or
staff.
Alderwoman.
Okay.
Sorry, Alderman.
All right. So, and you guys are happy with the arrangement you currently have?
very much.
It's been
All right.
working, yes.
So you're getting the people that you want in the right spots, doing the things you want them to do. And that's all budgeted, it's been budgeted for years, right?
Correct.
Okay. All right, I have no more questions. Does anyone else have questions?
And do you feel this agreement will help keep the students safe and help the community?
That's our primary goal, and we believe that, yes.
Okay. I think this is a good agreement.
And if I could just say thank you to the law department, because they worked over the Christmas break and New Year trying to get this done, given the time frame. So they
Thank you.
just want to thank them for all their work.
Thank you very much.
To close the floor?
Second.
All in favor?
Aye.
Okay, that passes unanimously. Any other questions or comments from anybody?
I would move to approve.
Second.
All right, all those in favor of approving?
Aye.
That passes unanimously.
Thank you.
On to number 1. Consideration with possible action on a request to fill the following replacement positions and all subsequent vacancies resulting from internal transfers. A is a police custodian, and B is a public works parking enforcement officer. Staff?
And you have the request to fill in here, so if you have any questions, you can ask us otherwise.
Any questions from anybody?
No.
I'll entertain a motion.
I'll make a motion that we approve the custodian and the parking enforcement officer.
Second.
positions.
Motion to approve in a second. All in favor?
Aye.
Aye, that passes unanimously. On to number 3.
No, two.
Well, 2 of which is still 3, kind of, yeah. Consideration with possible action on the grievance filed by Officer Jeffrey Brand regarding the personal file entry report issued December 17th of 2018. This committee may convene in closed session.
But, so we have to, should we start in open and?
Oh, sorry. I have
Oh, do you have
something to read.
something to read?
We're now on to item 2, consideration with possible action on the grievance filed by Officer Jeffrey Brand regarding the personal file entry report issued on December 17th, 2018. This is a continuation of the November 12th Personnel Committee meeting. At that time, the city moved for dismissal, and the committee held this matter to give the parties an opportunity to brief the issue of dismissal. To ensure a fair hearing, each member of the committee shall reconfirm that he or she does not have a conflict of interest in this matter and has not received any communication from any person or party. Each member, please do so by stating, "I confirm," and identify yourself, please.
Alder Dorf, I confirm.
Alder Purpose Dax, I confirm.
Alder Kathy LaFave, I confirm.
Alder Galvin, and I confirm. Today, the committee will consider the arguments made by the parties to determine whether the grievance should be dismissed. If the grievance is not dismissed, an evidentiary hearing on the merits will be scheduled for a future date. The committee members are in receipt of the brief from Human Resources Director Joe Falls to the Personnel Committee dated December 13th, 2019, as well as the brief on behalf of Officer Brand regarding the timeliness of his Step 2 grievance submitted on December 13th, 2019. The parties also requested that the members of this committee review the audio recording of the March 22nd meeting between Commander Kevin Warwick, Officer Brand, and Officer Brand's union representative, Officer Knudsen. Have all the committee members reviewed the audio recording? I need a
Yes.
verbal.
Yes.
Yes? Yes, okay, everyone confirms that they have reviewed the audio recording. Would the parties like to make any statements in support of the written submissions before the committee goes into closed session? Jeff?
No, not this time.
Okay. Police Department, or, Human Resources? No? Okay. If the parties do not wish to make statements, does any member of the Personnel Committee have any questions for either party?
I don't. I don't.
No, not at this time.
Okay. I don't either. If not, I will now entertain a motion to go into closed session to deliberate.
So moved, and I'll read the second, the words. The committee may convene in closed session pursuant to 1985 sub 1 sub A Wisconsin statutes for the purpose of deliberating concerning a case which was the subject of any judicial or quasi-judicial trial or hearing before that governmental body. The committee may thereafter reconvene in open session pursuant to 19.85 sub 2 Wisconsin statutes to report any actions taken during closed session and to consider all other matters on the agenda.
So, all those in favor?
Aye.
That passes unanimously. We are now in closed session.
Move to
Okay.
go back into open session.
Yep. I'll
Second.
entertain a motion. And a second. All in favor?
Aye.
Aye. That passes unanimously. Findings of fact and conclusions of law. This matter came before the Personnel Committee for a public hearing on November 12, 2019. A motion to dismiss was made by the city at the hearing, and the matter was continued to January 7, 2020, to allow the parties an opportunity to brief the issue of dismissal. Findings of fact. 1. This matter was heard by the Personnel Committee upon the mutual agreement of the parties for extensions of time rather than at the meeting that was first available after filing. 2. The parties were provided an opportunity to submit written documentation in support of their positions. 3. All of the submitted documents were admitted into the record. 4. The city moved for dismissal based on estoppel because the parties had already reached a resolution to the grievance, or in the alternative, failure to comply with the deadline set forth in the labor agreement. 5. Both parties submitted briefs in support of their positions. 6. Section 3.2 of the labor agreement requires that the grievant be identified by name, position, and signature in the written grievance. 7. Officer Brand is listed by name, position, and signature in the written grievance. 8. The written grievance is also signed by the union representative. 9. Both Officer Brand and his union representative, Matt Knudsen, were actively involved in the grievance process. 10. The deadline to submit the grievance to Step 2 of the grievance process was 15 working days from February 4th, 2019. 11. The city and the union agreed to an extension of the time to submit the grievance to Step 2 until February 28th, 2019 in an effort to settle the grievance. 12. On February 28th, 2019, the union notified the city that the union agreed to settle the grievance by reducing the discipline from 4 policy violations to 2 policy violations. 13. Between February 28th, 2019 and March 22nd, 2019, Officer Brand, Commander Warwick, and Union Representative Matt Knudsen met to discuss the terms of the discipline. During the meeting on March 22nd, 2019, Commander Warwick informed Officer Brand, and I quote, "You, by signing this, are acknowledging the fact that you have accepted, not accepted, but you have been informed that this personnel file entry will be in your personnel file." 15. In response, Officer Brand asked, and I quote, "And it doesn't revoke any of my rights for any future complaints or anything like that, or any legal aspect. It's not holding me that I'm agreeing to this, then, correct?" To which Commander Warwick responded, and I quote, "You know, that's a question for the lawyers. I mean, no. You have pursued the grievance procedure. The grievance was settled after step 1 before it went to the Human Resources Director. So that's my knowledge of it. 16, during that meeting, Officer Brand asked, and then the other thing, I have to follow up on with this on my behalf, this modification. Your understanding was part of the grievance process of settling of the grievance, is that correct? To which Commander Warwick stated yes. 17, during that meeting, Commander Warwick further stated, because my understanding is once you get to step 2, once the chief gets it, and if he denies, then the union has so many days to go present the grievance to the Human Resources Director. But at that point, the union, this is what I'm being told, the union owns the grievance and they determine whether or not to take it to the Human Resources Director or not. They chose to talk about it and settle it, which this is the result of, the settlement. In response to Commander Warwick, Officer Brand stated, okay. 18, Commander Warwick then asked, am I wrong? To which Union Representative Knudsen stated, you are correct. 19, Officer Brand then asked, are you aware of the chief's denial or the rejection of the grievance? To which Commander Warwick stated, yes. Number 20, Officer Brand then stated, okay, then I will sign. 21, Officer Brand stated later in that meeting, so this in your mind, in from what you're doing, this is done. To which Commander Warwick responded, hopefully we never have to talk about it again. 22, before the meeting concluded, Union Representative Knudsen and Officer Brand asked if he could attach a rebuttal to the personal file entry. Commander Warwick notified them there was no problem with that. 23, Officer Brand concluded the meeting by stating, okay, I think that's it. 24, on March 22nd, 2019, the city reduced the discipline from 4 policy violations to 2 policy violations. Number 25, on April 5th, 2019, Officer Brand submitted the grievances to step 2 of the grievance process. Conclusions of law. 1, this grievance is properly before the Personnel Committee pursuant to Article 3 of the Labor Agreement. 2, a hearing on this matter was timely conducted in accordance with Article 3 of the Labor Agreement. I'm not going to do all the cites, the legal cites, but 3, the principles of contract law apply in resolving disputes under collective bargaining agreements and in arbitration as elsewhere. Waiver and estoppel are established doctrines. 4, the elements of equitable estoppel are 1, action or non-action by the person against whom estoppel is asserted, 2, which induces reasonable reliance thereon by the other, either an action or non-action, and 3, which is to his or her detriment. 5, the element of equitable estoppel is whether the party against whom estoppel is asserted caused another party to change position to his or her detriment. In the context of a claim of equitable estoppel, detriment has been equated with prejudice and commonly understood to mean injury or damage. 6, in construing terms of collective bargaining agreement, various sources may be considered, including the express language of the agreement, statements of the parties in negotiations, bargaining history, custom, and past practice. In factual disputes such as whether a grievance is settled, the party's conduct may also be considered absent anything in the labor agreement to the otherwise. 8, the evidence shows that the parties reached an agreement to resolve the grievance during the discussions among the city, Officer Brand, and Union Representative Knudsen at the meeting on March 22nd, 2019. During the meeting on March 22nd, 2019, the evidence shows that Officer Brand understood that the personal file entry amendment was final and for the purpose of settling the grievance. 10, the evidence shows that the city reasonably relied on that agreement to settle by amending Officer Brand's personal file entry on March 22nd, 2019. 11, the evidence shows the city reasonably relied on that agreement to settle by removing the original personal file entry, which included 2 additional charges. 12, the amendment of the personal file entry was to the city's detriment. 13, Officer Brand is therefore stopped from pursuing the grievance and this matter is dismissed. 14, as this matter is dismissed based on estoppel, there is no need to address the issue of waiver. Entertain a motion.
A motion to approve the dismissal based on estoppel.
And adoption of the findings and conclusions.
And an adoption of the findings and conclusions.
And a second?
Second.
All those in favor?
Aye.
Any opposed? I'm sorry, this matter is concluded. Everyone, there'll be a copy available when this goes to city council next Tuesday.
Thank you.
You want these back, Vanessa?
Yeah.
If the parties, she can give them to the parties, so she can put it more.
There's a typo.
Yeah, I saw.
Okay, all right. I don't remember.
All right, so,
We have more stuff.
yeah, informational. Under informational, report of routine personal actions for regular employees. Staff?
Do you have any questions on the report?
I have none.
I have none.
Entertain a motion.
To receive and place in file? To receive and place in file.
All those in favor?
Aye.
And the next meeting date is January 28th, 2020. And
Move to adjourn. Second.
all in favor?
Aye. We're adjourned. Oh, I gotta leave the meeting.
To adjourn.